Okay, hi. Thank you so much, everyone, for being here for our client Zoom meeting this quarter. We're going to have a couple of speakers joining us today with some great topics. So we'll kind of get running right into this right away. The agenda for today is it's 12 to 1. We might end a little bit early, but we'll see. Definitely try not to go overtime. That's the one thing we don't want to do. And we're going to start with Jackie Lauer. We're going to have a little bit of what's new with H2R. We're going to move into trending and employment law with Pamela Kraus, and then we'll have some Q&A at the end of that. So your speakers or presenters today will be Jackie Lauer first. I'll give that update on H2R, and then we'll have Pamela Kraus. Also want to let you know that you can click on the chat button if you have any sort of questions or you want to share some comments. You can raise your hand. I'm going to do my best to try to catch everything that's happening on my side panel there. And if not, feel free to even just sort of let me know with your voice. Just unmute yourself and let me know that you've got something to share. Be happy to deal with any of that. So first up, we have Jackie Lauer. Jackie is a workplace culture expert and an executive coach. She has over 20 years experience working with executive leaders who are looking to make changes within themselves and within their workplace cultures. We are absolutely thrilled to partner with Jackie as H2R's leadership development partner. She's going to let you know today about the leadership development programs that are available through H2R with her leading. And she's going to give us 4 reasons to invest in leadership development programs. And I know I'm actually really thrilled to hear this part of our meeting today. So Jackie, I'm going to turn it over to you. And
thank you.
Give me just a moment. Need to find you here. Sorry about the delay.
Let's just stop share and then I could start to share.
There you go. You should be fine. There you go.
There we go.
Thank you.
There we go, team. Let me open it up. Come on, large. There we go. Hey, gang. Good to see you. It's been a while, so it's nice to see all your faces. I'm hoping we get to do this in person soon because I'm feeling the need to get out and experience the world. Some of this, you know, so hopefully I don't put you to sleep. Hopefully it's a little new for some other folks. So I've been doing this, as you know, on my own for 23 years, but you know, the beautiful Jill has been a champion and a very dear friend for a long time. So I love working with H2R. I'm here to help you around leadership development and any executive coaching programs. So my background, who gives a shit really, as long as I can solve your problems, but in case you want to know, certified emotional intelligence, neuroscience, change management, and various different coaching programs, systems coaching, narrative coaching. Most of my clients couldn't care less, but for the odd one, they might want to know where I get this knowledge from. There are really, from my perspective, looking at the clients I've dealt with over the years, there's really 4 reasons that they step up and say, I think we're going to put some money aside for leadership development. And it's often around things like, number 1, we want to improve our bottom line financial performance. And one of the ways we believe we can do that is by being better leaders to our people. So our people essentially goes to number 2. We want to make sure that we're attracting and retaining our talent. And especially post-pandemic right now, that's the number 1 reason people are coming to me is we're having a hard time hanging on to talent across all industries, big and small organizations. It tends to be the reason that people are coming to me. It's like, how do we bring empathy and compassion into the workplace? How do we manage the constant change? And those tend to be the reasons that people are coming to me. The other part is number 3, we want to drive strategy execution. And because there's a lot of change coming at us, there always has been, but even more so now with technology and the world getting sort of smaller because we're more virtual, we need to do a better job of communicating any strategy. And so I always say, as a change management consultant, I moved into culture because culture eats strategy for breakfast. And at the same time, as the more I moved into culture, the more I started to understand that the quality of the conversation is going to drive some of that strategy, is going to drive our leadership. So And then the number 4 reason that people tend to have these conversations or choose to put money aside to invest is they want to increase their success in navigating change. So for instance, yesterday I did a speech with the region of Waterloo with their whole admin group because they're just constantly diluted and overwhelmed by the change. And so what are the nuggets that I could give them to help them to navigate through constant change? Or an organization I worked with last year on how do we bring a change management framework into the organization that we're all using so that we can find alignment faster. So those tend to be the reasons that companies will choose to invest in leadership development. So how do I work with you and work directly with you and or your internal sponsor? So you could be HR, but you want your chief financial officer to approve, or your CEO, or whoever it is that we're working with. I'll work with you. I'm not here to step on your toes. I'm here to help you do the work that you need to do with your internal clients. So leadership development strategies can include everything. That's the work we've done with H2R. It could be ready-made training that I've already got, and I might just slightly tweak it for you. Often it's customized. I'm a big fan of, if I can build something that aligns to your values and your culture to make it more palatable and fit into your culture, that makes a lot of sense. There's leadership coaching. So I've done that in a one-on-one setting or in a group setting, and we've got other coaches at H2R as well. So know that there's a number of us that are available to you. The group coaching piece has been getting interesting traction over the last 3 years. So I'll take a leadership team like at DeGero, and we would give them specifically designed training once a month and do individual coaching in between. And in the case of DeGero, I also did group coaching. So once a month, how do we apply this? How's this relevant to this journey we're on right now? What's a problem that we are facing that we can solve with this new insight and this new learning? And so they start to learn to peer coach and also provide the coaching skills to themselves and to those they lead. And then of course, facilitation. So because I grew up as a facilitator and change management consultant, I'll come in and do keynote speeches, or just yesterday worked with a client on designing their 2-day leadership retreat. Because I have a lot of leadership frameworks or methodologies, I'll say, okay, let's brainstorm your agenda, and so lay it out so it makes sense and it's palatable and suits the culture. So I'm here to help you either A, design that agenda, or B, be facilitated. So those are the ways that we can help. I hope that gives you a little bit of context.
Jackie, can I just jump in for one quick
second? Of course.
Because I think this is really important to mention, especially for our clients that are under 100 employees, which most of you are. There is a grant out there called the COJG. Don't ask me what it stands for right now, but it's a training grant, and it has funding up to $10,000 per person. And oh, Erica's on here. Erica, do you want to jump in for a quick second and talk about this for just 2 minutes?
Sure. How are you, Jill?
Hi, Erica.
Hi.
Nice to see you.
Yeah, good to
go
see
ahead,
everybody. Yeah,
this
for
would
sure.
be perfect for some of our. So you go ahead and just talk about the program for just a couple very quick minutes.
Okay, great. So, sir, can you hear me? Okay.
I can, but somebody needs to be muted. I think it's Paul. Paul, if you can mute yourself, or Alini or Deborah, please.
Great. So basically what the grant does is it offers the funds to help you train your current or new employees, depending on what your situation is. But it again is for any size company. The companies that have under 100 employees would benefit more. They would be covered, the tuition would be covered for 84% of it. And companies over 100, it's 50% that's covered.
84%. So
yes,
those
84.
under 100, the grant is covering 84% of the training costs. That's huge.
It's significant. Yeah, and we've had a number of clients manage to get the grant. So just know that it's not as difficult as it sounds.
It's not. And I was going to just say, sorry to jump in, but you know, for any of those companies that are looking for assistance with the submission, even if Conestoga is not the service provider, I certainly am available to help submit the application on their behalf and work with them just to make sure that, you know, they can, you know, they filled in everything the way it should be and that it's submitted timely.
Thank you, Erica.
Yeah, no
That's
problem.
awesome. Thanks for thinking of that, Jill, and inviting her in. You know, and I think on a couple of the clients that have sought it, they'll look to us as well to help fill in that application. So we're here to help. So you might not be able to say, go, yes, we'll do this until you have the money. We'll be a part of the process if you need us to help. Don't worry about that. Absolutely. Hang on, let me get my cursor in the right place. Just an example of some of the available programs. Everything from the emotionally intelligent leader to courageous conversations, managing change, leader as coach. These are the ones that I do on a regular basis, but often take something like this that's already been designed and tweak or change it to suit your culture. Even in terms, you know, remember the day pre-pandemic and when we do 2-day workshops in person? You guys remember that? That's not a thing anymore. And it's not a thing for a multitude of reasons. So just changing it to suit your culture, these are available to you. And then we can change or adjust accordingly. So it absolutely can be tailored. Excuse me. The bottom line is that a small business with no training department or a large organization with lots of resources, basically customized training can be a big boost. It can just have a greater impact. So I think about working with Christy, or I think about working with, there's just one, this, like even the Region of Waterloo, Activa is a client right now. And so what I do is I say, please share with me your mission, your vision, your values, share with me any engagement surveys, because it gives me context to make sure I'm speaking their language. And then of course we can do the ready-made programs, right? It comes down to knowing when to use them and how to leverage them that makes sense and gives meaning to the investment that you're choosing to give to your leaders. All right, just an example of some
Deborah,
of the clients that have benefited.
Deborah, sorry, can I just stop you? I think people are trying to come in. I don't know if you can, because you have the PowerPoint open. I don't know if you can see the waiting
No,
room.
unfortunately,
Sorry.
I think they're coming up on poor Jackie's
There.
screen.
I just
I'm so
admitted
sorry.
them.
Oh, thank you, Jackie.
Yeah, I wasn't able to do it. I'm so sorry about that. Okay, good.
Hello, everyone that just joined. This is Jackie Lauer, and I'm so sorry I didn't see you in the waiting room. Alini,
No, that wasn't
Alini
your
had your
job.
back.
Yes.
All right.
All right, it's Corey. Hi, and my camera has gone kaput, so you can just put a funny face there instead. Hope everybody's well.
Thank you, Corey.
As long as you can hear and see us.
Yes, you
Okay.
got it, loud
Great.
and clear.
Awesome.
There you go. Well, gang, that's the overview. This is some of the options, why we invest in leadership development, what's available to you through me. Feel free to reach out anytime. You know, there's no commitment. It's just, I always say, I'm here to help you brainstorm. You know, I call it the design meeting. I'm not going to charge you. We're here to help you figure out what's the right thing for you in the right time. So at any time, reach out and we'll have that conversation. Any questions that you have?
Everybody's so quiet today. What's going on? It's not a Monday. It's a Wednesday. No, this is great. Thank you for the update, Jackie, because I think we often forget how important it is. And what I'm hearing from a lot of our clients, especially, you know, in the last year, is that people have been promoted and promoted and promoted, but never given the tools on how to actually lead people. So you get promoted, you get a team of 4 people. And then that team gets added on with another 10 people. And a lot of people just don't know what they don't know. And so one of the programs that I love the most that Jackie runs is the Manager Boot Camp, or as Alini on our team calls it, the Manager Booty Camp.
I can't help you with your booties, that's for sure.
We need a booty camp. So it's the Manager Boot Camp. But if you've got a group of managers, then customize a program that's to your organization, your key values, your key strategies and goals, et cetera, et cetera. And I'm telling you, to do a couple of days with Jackie would be a lot of fun. Would be a lot of fun. So I will be quiet now and turn things back over to Deborah.
Well, I was actually going to ask Jackie, can you speak just for a quick minute? And the Manager Bootcamp was the one actually I wanted to ask you a couple of questions about, because I've actually had a couple of conversations with clients this week who are actually interested in that, who are feeling like, especially for businesses that have grown quickly through the pandemic time period, they've had to lift people up into manager positions, who don't really have the training or the experience, and they're kind of struggling with, you know, making that role work and making it work in a culture that is hopefully based on, you know, retention and good culture and things like that. So if you could speak just for a minute about what that manager boot camp kind of looks like. I know you've got different levels and different offerings, and they look like they're just really fantastic trainings.
We did do a core program and a foundational program, and that doesn't exist anymore, Deborah, only because what I've noticed is it's like, I'll take the essence of the boot camp and then make it fit for each company. And I prefer that because you can get, you know, 5 to 10 managers that have never had training, and now they've got similar frameworks and similar language to lead in alignment with each other. That's my bias. I love it when a company, I'll say, if you're going to have 3 people in the public program, let's create one for your organization that can be repeatable if you can. So topics are typically around things like, how do we, like a lot of times I think about, we have a mission and vision, but do you know how, like, do you know them? And how do you use them for your, we have values? What do we do with values? No one talks about values. So I'll talk about how do we use values as a manager to make them livable and real and not just espouse values. We'll talk about things like strength-based leadership. So what are your strengths and how do you lead and inspire people to live their strengths in their job? How do we have difficult conversation? How do we give and receive feedback? So those tend to be the topics. They're usually 2 to 3 hours. We can spread them out weekly or monthly so that there's a cadence to the learning and time to apply the learning. I love it when we can add that sort of adult learning theory, which means we need time for reflection to go, what did I take away? And am I actually practicing this? Because we all know that only 20% of learning and training programs get retained unless we give them space to apply the learning and reflect on the learning. So I love it when we can do the boot camp style with time for reflection and application. I hope that helps a little bit.
I think that helps a lot. I love that. And one of my favorite things is when you talk about mission, vision, values, and people will be like, well, we have it on the wall.
Right. Do you know it though?
Yeah, absolutely. That was really great. Thank you for all of that. And
You're welcome.
it's a lot to unpack, but I just think if you guys listening are interested, you can explore our website and explore Jackie's website and see what kind of options are available, because I love the flexibility that you have. I just feel like you meet people where they're at, and I think that's so important. So,
And isn't that what we do as HR professionals, right? We're trying to help leaders learn to do that too. So we should do it. What a concept.
what a concept. I love that. That's so great. Well, thank you so much for that. All right. Well, I'm going to go back into our little slide presentation here. So bear with me. So again, thank you so much for that, Jackie. Really, that was time well spent as far as I'm concerned. So hopefully everyone else got stuff out of it as well. Yes, thanks, Jill. She's clapping for you. Okay, so we at H2R are really kind of leaning into and investing a little bit more in our training and development programs as well through Jackie, but also internally, and also working with some other external partners. So over the next little while, we hope that you'll be able to see more of that coming from us. You'll also see in the next little while that if you notice on any of our signature lines, you're going to see a nice little click box that'll take you right to our training website pages. So you'll be able to see where we add more, and obviously we'll spread it more to you through emails, on our socials and things like that. You'll get to know a little bit more about the different kinds of trainings that we're focusing on and trying to support all of our clients with. This is, as you
Sorry,
probably,
can I just jump in for one quick sec, Deborah?
anytime, Jill, absolutely.
Okay, I have to give a big shout out to Nate. Where's Nate? Give us a wave, Nate.
wave,
Nate from
Nate.
my team from H2R. This is sort of the training has been his baby. And as all of you know, in the province of Ontario, we have compliance training that is mandatory. Every single employer with more than one employee has to have their employees do this compliance training. We've got it all bundled together in a great little package for $65 per employee. And there's five modules or 6, Nate? give him a sec to come off mute if he's there. Maybe he's not there. Anyways, there's 5 or 6 different
Five,
modules.
sorry. Sorry,
Five?
Jill, I was putting my hand up to say 5.
Oh, 5. Okay, good. So these are all online. It is super easy to do. And then Nate has continued on and developed a bunch of other training programs. So just to highlight a couple, diversity, equity, and inclusion. This is huge right now. So there's a module on that. There's an online module on that. Mental health. He just launched goal setting. We'll be doing one on generations in the workplace. He'll actually be doing one in partnership with Jackie Lauer next on leadership. So if you haven't checked this stuff out, check it out because it's not expensive and it's super easy to do. It is all online, but a huge shout out to Nate because he's been the man behind all of this, making it happen. So thank you, Nate.
Thanks so much for mentioning that. I'm sure Nate is thrilled too that we highlighted him. No, that was awesome. And it's really, the work is so well done. I really encourage people to just kind of look into what we've got because it's a really high quality training. So I'm excited about what we have and about what we'll have in the near future as well as we continue on. So what's new at H2R? That's part of what's new. We're going to be investing more into more trainings. You're also going to probably notice that I'm new. I'm new as head of client success. Hi, welcome everyone. You'll see on our next page here, this is an updated listing of everyone who is partnered with H2R. You'll notice at the top too, 7 years in business. That's a new ad. I just fixed that because as of May, it's the 7th year anniversary for H2R. So congratulations to Jill and to everyone at H2R, 7 years. So that'll be our new banner for a while for the next year. And this is a list of all the people who are working with us. And you'll see one new senior HR consultant's name as well, Christine Holman. This is a list of everyone who supports us and works with us, and you as clients will know a few names on here, particularly, you know, consultants who are working with you and things like that. But we've just got an amazing team that brings such a wide variety of experience and passion to the roles that they do, and it's very exciting. So we're at about 30 people and counting and growing.
Well, and the other thing is too, we've got a couple of four-legged furry friends that really run the show around here. At least they do here. So Millie is our HR apprentice. She's currently under my desk chewing on something probably that she shouldn't be chewing on. And then we've got Riley, and she's over in her little dog bed beside me over here. Best dog ever. She's our chief furry officer. So she's our CFO. And Millie is on a PIP actually right now. Millie's on a performance improvement plan.
Still, it's ongoing, right?
And in training
Yeah.
training. So she should be paying attention to this session.
But is she? Not so much. Yeah. It's great. I always think that the best part of any meetings is when people have their dogs or cats in the background. So I love that. Mine is currently asleep back here too. All right. We have some other new things happening at H2R. Some of our families are growing. We have 2 consultants going on mat leave beginning in the summer, and we have one going on parental leave. So we think that that is just amazing. It's always so amazing that families are growing, and it's such a wonderful thing for companies to really support their team growing their families and support them in all the ways that are either, you know, legislated, but also just from an emotional point of view as well, making people feel that this is something that's a good thing and that we all want to support them. Our business is also growing, and for that, we're very appreciative. Really, there's a lot of gratitude for being able to grow the business, adding new clients. We have such a treasured group of clients. Jill has client connections going back well before even the start of H2R. I mean, I'm amazed at the connections that she has going on, some of them, I think 20 years. And that's just such a strong testament to her networking and personal abilities. And so many people have worked with her throughout all these years. And that's just something that we're proud of. And we're thrilled to see new people coming on board all the time. The region is growing, and we're really thrilled to be able to support HR in all of the business that are coming into the region. So that's something we're excited about. And I showed the excitement with all the colors. Now I am very excited to be able to turn this over to Pamela Krause. I'm going to tell you a little bit about Pamela. You've got her bio there. The quick sort of talk about Pamela is because she has so much experience. She was accepted to the bar in 2006 and has over 15 years now experience in employment law. She's litigated difficult cases, which is really something to note, at trial level and appeals. She enjoys working with entrepreneurs. She's a trusted advisor to many of the small and mid-sized local businesses in the region. And we're really thrilled to be able to have her speaking today on this topic. The topic is denying enforceability of agreements and awarding extra damages. She's noting this is trending in employment law, so that's the topic that she wanted to bring. And I think that this is the kind of information that every business owner should probably want to hear and maybe be aware of. It's a really important part of what we'll learn about today that I think is not easy to learn about in just in the news kind of a thing. You want to hear from an employment lawyer point of view. So Pamela, I am actually changing the screen over to you. You should be able to start sharing.
I think I'm off of mute now.
Hi, Pamela. I didn't
Hi.
Yeah, nice to see ya. Welcome.
Hi, everybody. Thanks, Jill. Thanks, Deborah, and everybody here for having me today. And congratulations, Jill and team, on your 7 years anniversary today. That's super exciting. I've known Jill for a while, and I remember when H2R Business Solutions first came to be. I can't believe it's been 7 years, but all you've done in 7 years is remarkable. So congratulations. I have to say, I tuned in at about 20 after, and you guys are such a fun group, and H2R is always doing fun things with the furry executive and such. I kind of feel like the downer of the meeting now, coming in and talking about the Court of Appeal and Superior Court of Justice decisions. It's like yawn probably, so I love this stuff. I find it fascinating. So hopefully there's some nuggets in here that you guys appreciate as well, but it's definitely a little less fun, I think. So I do have some slides I'd like to share if I can, Deborah. Can I share a screen here?
You should be able to share a screen.
Okay.
You'll see it should be highlighted in green for you. Yeah, that's great.
Can you let me know if that's working?
Yes, it's a bit small. I don't know if it's a full-size screen.
Shoot, hang on.
There's a view options that might do more of a big screen. Otherwise, I think we're fine. We can all see it.
Can
It's
you?
okay like that.
Yeah.
We can read it.
Yeah, we can read it. It's good font size. Yeah. Hopefully everyone's good. I see the
All right.
concept page up. Yeah.
It shows someone in the waiting room, Deborah. Should I admit them?
If you don't mind, I've lost control
Okay.
now. So yes, thank you so much.
Okay.
Great.
All right. Okay. Sorry. Hang on a second here. I'm just going to stop.
Thanks, Kyle, for letting us know. That's good.
Sorry. Just bear with me. My apologies.
Oh,
I'm just
no,
going
not at
to-
all. No worries.
I was going to bring my tech person in with me to make sure I got this up and running.
You know, the one thing since the pandemic I find is everyone's just at ease with this stuff. We just make it work. It's all good now.
We're a
Yeah,
little
it's
more
okay.
patient.
Deborah, do you have a copy of Pamela's slides?
I don't know.
Okay, that's okay. You got time, Pamela, no rush.
Okay, hang on. I can do this, no problem. Okay. The challenge might be, all right, let me do this. Share screen. Yeah, that's probably as big as it's gonna get. So,
And
I
that's
think,
totally
yeah.
okay.
We can read
All
it. I'm
right.
pretty sure everyone is feeling good about it.
It
okay,
totally works.
perfect. All right, so thanks for introducing the topic, Deborah. It gave me a chance to kind of hone in on a couple things that are happening in the case law. As you H2R professionals know, things are always evolving and changing, and every new fact scenario that goes to trial seems to somewhat give judges the opportunity to see things differently. And and apply our new kind of social norms to what's expected of employers. So I guess the one thing is why I often get from clients, why do I care what the courts are doing? I don't want to litigate. I don't want to end up in court. I don't want to be the one that the judges are making a decision about. But the reality is everything that comes out of the courts really influences a negotiation of disputes with your employees. And so to the extent you have yourself in a precarious legal position because of new case law coming out, you're really going to be at a disadvantage in a negotiation, and any good employee legal counsel, which myself and my team, I like to consider us as, will be raising these sorts of arguments in a negotiation of any sort of termination and severance. And so it's important to try and align yourself the best you can with current law, so you put yourself in a good bargaining seat really when you're dealing with disputes with employees. So the first trend, I picked kind of two. The first one is the broad application of the change substratum doctrine. And so that sounds quite legalese. Substratum essentially means underlying layer or substance or the foundation or basis of something. And so this is a common law principle that goes back into contract law years and decades ago, and essentially is the concept is if the fundamental the fundamental terms of a contract have changed, and in employment law, it's really if there's an expansion in the employee's responsibilities and change in their employment, then essentially the agreement can no longer at some point be said to still exist, as it no longer really reflects the reality and the true nature of the employee position. And so essentially the law implies that a contract could not possibly have been intended to apply in those circumstances, and ultimately it no longer is enforceable. And the problem with this is, of course, if it's not enforceable, then you can't rely on provisions such as the termination provisions when dismissing an employee. So generally, this hasn't been a doctrine with a lot of focus, because usually it traditionally has been applied in really extreme circumstances where you have an employee that starts kind of at the bare minimum entry level position, and then suddenly over 20 years becomes, you know, CEO. That sort of situation where there's such an extreme change and multiple promotions over years that it seems odd to rely on an old agreement. So those are usually the circumstances that this has been applied. But what is trending now and has come out of our courts is a real significant broadening of this position and this principle that is important to be aware of. And so the Ontario Court of Appeal recently, in the decision of Celestini and Shop Logic, upheld the Superior Court motion judge's decision that an employer's duty had been altered over time to the point that the employer could no longer rely on the termination provision signed, which was signed over a decade in advance. And so Celestini, the difference in this case is this was not a vulnerable, unsophisticated employee. Celestini actually was a co-founder of Shop Logic. And in 2005 sold it. He was CEO when it was sold, and they sold the company, and he stayed on as the CTO and maintained employment. Additionally, there was an employment agreement where there was a 12-month termination clause. So this was not kind of a minimum type of clause, 12-month clause in his contract. And so in 2008, 3 years later, they really expanded his role, still stayed CTO, but expanded his role to cover a lot more responsibilities within the organization, and importantly, had him sign an incentive comp agreement where he was given a lot more executive compensation. And so in 2008, there was a real broadening, a lot more on his shoulders, and he was being paid to reflect that. So move forward to 2000 and I believe 12, 2000 and yeah, no. I don't know, it's 12 years after. So yeah, I think 2012, 2013, Shop Logic terminates his employment and tries to pay him out the 12 months. Well, him and his counsel take the position that the agreement back in 2005 could not be relied on, and he was owed 18 months of severance. The 12 months was not enough given how long he'd been there and his position at that time. So the Superior Court of Justice agreed and he's awarded 18 months, which the difference in damages from what he was paid to the judgment was over $400,000. And so this was very significant for ShopLogics. So not surprisingly, they appeal to the Court of Appeal. And just recently, a few months ago, the Court of Appeal came out and upheld the decision. This was somewhat a surprise, I think, to the employment law bar, because we were always under the impression that you needed a promotion, you needed a title change, you needed something really substantial to change for this doctrine in common law to be effective. And the Court of Appeal said, no, it has to be, you have to really look at the context. The title changing, yeah, we're going to look at that, but it's not determinative. So you don't need a title change, you don't need a clear promotion for there to be enough change that this doctrine applies and the contract just no longer makes sense. So that was a really significant decision coming out of the Court of Appeal. And really the takeaways from this for employers is to be mindful of, you know, the new rule in my books is not just introduce a new contract if there's a promotion. If you're changing the compensation plan or the real scope of duties for any of your employees, and it's pretty significant, you should really be working with HR, your legal counsel, to ensure that there is a new agreement put in front of that employee. And the good news is if you're changing the comp plan, you're going to have consideration for that agreement too. So it's a perfect time to get a new agreement in front of them. So to be
Pamela,
yeah.
it's Jill here. Can you just explain briefly what consideration is and why consideration needs to be given?
Yeah, yes, absolutely. So consideration is a contract law concept. It applies to all contracts, not just employment agreements, where the two parties to contract need to give each other something in order for there to be enforceability, for there to be a legally binding contract that the courts have authority to enforce. And
so you can't just put a piece of paper together and say, Joe Smith, congratulations, I'm promoting you to director of sales, and here you go. There has to be something in exchange for going into something new, because it's a new term of employment, correct, Pam?
Yeah, yes, both parties need to get something new. And so this with employment, especially because the courts see the employee as vulnerable and the weaker party. And so consideration they're very particular about, and the employee needs to get something new. So when you introduce a contract, you better be giving them something that they don't already have, and they already have their job. So continued employment has repeatedly been said to be not consideration, like the threat of you have to sign this or you're not going to have your job, doesn't work. They need to get something they don't already have. So in the case where you're increasing compensation and duties, you know, you have that piece. And so it's a great opportunity to introduce that agreement. The other takeaway, I know in the agreements that we work with making custom templates for our clients, our employer clients. And one of the things that we're very mindful of now is getting language into the agreement that addresses this change to substratum. So there can be language in the agreement now. You know, we hope that it's ironclad, but you never know what the courts are going to do. But the language essentially says the intention of the parties is that this continues despite any changes to the employee's duties, responsibilities, compensation, et cetera. And so you contemplate the terms, especially the termination terms, still having enforceability, even if there's change. So adding that sort of language into the agreement out of the gate also can help deal with this issue that's arisen in the law and be proactive with it. All right, so the second trending thing that we're seeing a lot of right now is this low threshold for extra damages. So what I mean by that, extra damages, there's two components really. One is punitive damages. So punitive damages are very rare usually, but we're seeing them awarded a lot more in employment law cases. And the court uses punitive damages to deter, punish employers for conduct that it wants to deter. It's the way of the court denunciating or showing retribution for certain employer conduct. And they're using them more and more, we're seeing with really low thresholds of conduct by employers. The second extra damages is moral or aggravated damages, and those are really to compensate an employee for injury. And so that's when an employee is saying that something in the manner of the dismissal or the way they were treated by the employer caused them excess injury more than the usual distress caused by a termination. And those moral aggravated damages are to compensate for that injury. So one's compensation, one is actually punitive. And we're seeing a trend with both of those to be awarded more often with very low thresholds in the courts. And so I have a couple points here. What we're seeing is really hypersensitive employees that get upset and distressed easily. They're increasingly being awarded damages for the pain and suffering after the loss of their jobs. Historically, the threshold's been pretty high, and getting these extra damages has actually been exceedingly rare. Usually the employer has to do something pretty egregious and offensive for these things to come into play, is usually the advice we give to our clients, but that may not be the case anymore. The courts have been, placing greater emphasis on hurt feelings, and they really are having a trend where they're talking a lot about in the decisions the employee's vulnerability, especially at termination. So the court really has a lot of empathy for employees that lose their job. They're really focusing on the vulnerability of employees and expecting, because of that, the employer to really take a high level of diligence in affecting these terminations of their employment. So what we're seeing from the courts is a lowering of the threshold of what demonstrates what the phrasing in the court, the literature is a marked departure of the ordinary standards of decent behavior. So that decent behavior used to have a high threshold. Now, the smallest things, in my opinion, the court's considering to not be necessarily decent when it comes to employer conduct. So we're seeing a really high expectation of technical diligence, which is why I thought I'd really highlight this trend for you all today, because there is no need to be malicious. You don't need to treat an employee badly for these things to be at play. You simply need to be a bit careless and not really completely mindful of the technical requirements in law in order for these damages to potentially come into play. So I have some examples to kind of highlight what I mean by this all. I have 4 cases, the 3 of them have been released in the last few years. The first one is brand new, 2023 decision. So in Telesur and Allura Hotel Group, it's a general manager of a golf resort that is terminated, I think after about 12 years of employment, and they really screw up his ESA entitlements. They don't pay them right away. They take a couple months to pay them, and they also don't properly pay his expenses that he had for reimbursements at the time of termination. They dilly-dally around and months later finally pay it. The court thought that the employer's conduct was problematic in both failing to meet the ESA requirements of paying those minimums and also the expenses. They thought it was inexcusable for them to withhold reimbursement of those expenses for a couple months. And so they awarded $15,000 in moral damages. They found the employer did cause extra distress by not being diligent. So similarly, in another similar case, Moffat and Prospera Credit Union, this one's really interesting because this is in the context of a big organization or reorganization. So the HR team was letting go of 100 and so employees, and they used the template letter where they stuck in everybody's name. And I see this often in my practice. I can tell when I get a template termination letter. And they stuck in the numbers and the name, and they screwed up the calculations of the ESA termination pay and severance pay, and they miscalculated, and that fell short of what they were supposed to pay. So interestingly, the court again thought this was inexcusable. You need to get it right. Essentially, the court said about the employer, and they said, we don't care that you were doing 100 terminations. There is no volume discount on the correctness of a termination letter, is what the court said. They also said a cookie cutter termination letter drafted without regard to individual circumstances of each employee falls short of the standard required. And so what the court's saying really in this case is that you need to get these things right. You need to pay close attention to each individual employee's entitlements and get this right. If you don't, you know, there's going to be a risk that the court takes issue with that and looks to these extra damages to deal with it. I think I have a question, maybe Deborah. Here I see a hand raised.
Whoever has their hand raised, do you want to unmute?
Yeah,
and
that's
ask the question?
Rochelle. Go ahead,
Oh,
Rochelle.
Yeah, I just had a quick question in regards to the trends that you had shared. I'm curious if you have any insight to what is driving those trends, if it's the current economic conditions, or if there's other external factors that are driving that, and if you think that it's likely to change.
Yeah, I mean, that's a really good question. I've given that some thought myself. I somewhat personally think perhaps it's a bit more mindfulness of just emotional and mental health overall in our society, and being appreciative of how vulnerable employees are when they lose their job. You know, job loss is often looked at as a loss, and you grieve it and you go through, you know, the stages as though someone has died. And so I think the courts are really just getting sensitive to that and how distressing the whole thing is on employees, and that if things aren't done right, it's even heavier. And so they're tending to hold employers really accountable to be really mindful of this and be aware of how important this is for employees. And it's not simply a transaction for them, it's their life. And it can wreak havoc on them emotionally if things aren't done right. So I think it's that whole trend of being more mindful of our mental and emotional wellness that's being reflected, is my personal opinion, in the judgments coming out. There's a higher threshold expected of employers, and we live in a world where employers have the access to HR teams such as H2R Business Solutions, and they have access to information and knowledge, and the court's expecting that to be used prudently, and they just are putting that threshold and standard up for employers because of that. So those are my thoughts, just impressions, but great question. Thanks, Rochelle. So I have a couple other decisions here again, Russell and Brick. This one as well, in this decision, the employer used the template letter, and the court really fixated on that. The court even said the termination letter provided to Russell in this case is the focus of the analysis of punitive and aggravated damages. So we're seeing the courts like pick apart termination letters, and these termination letters are becoming, you know, serious evidence that the court's critiquing. And so when you're putting together a termination letter, you know, it's a little bit more pause and think, like, a judge may be looking at this for sure someday. Or, you know, plaintiff's counsel, employee counsel is going to, and they're going to look at it like a judge. So you want to get it right. So interestingly, and I really raised this one, is in this case and the next case, the termination letters, and you guys may want to look at what you do in termination letters, but in this termination letter, it wasn't clear that if the employee didn't accept the package being offered, that they'd at least get the minimum Employment Standards Act amounts. It came across as an all or nothing. And so the court took objection to that and said it was kind of misleading, and it was a serious defect in the termination letter because it left the employee with the impression that if they didn't sign, they weren't going to get anything at all. And that wasn't the case. They were going to get some pretty significant minimum payments in this case. And so the court found that to be a failure of the employer to deal with the employee fairly. They thought it was misleading, and they objected to that. Yes, Jill.
And Pamela, if anybody isn't familiar with this case, it's one that you might want to look up. And correct me if I'm wrong, but isn't this the guy, so Russell, wasn't he the sales guy who was marking down furniture and whatnot and selling it to his relatives? And this went on for a whole period of time, and I forget how much money it equaled up to, but is this the case that I'm thinking of?
I'm not sure that this is the same case. No.
Oh, okay, because it was either the Brick or like one of the big furniture stores.
Yeah, I don't think this is
or Leon's. Maybe it was Leon's.
Yeah. I think that's,
Maybe it was Leon's.
I think
Anyways,
that's a different one.
some of
I-
these cases that Pamela brings up, you may want to look them up because they
Yes.
are quite interesting to read.
These ones, these four actually really are. I've read them word for word, and a lot of really good one-liners come out of the court. You can see how interesting judges can be in these cases. So, the
Yeah,
judge
thank you.
Yeah, the judge in this case said, like, this guy was there for 36 years too, so that's always going to come into play. Courts are always a little bit empathetic towards long-term employees, but they not only did an all or nothing type of termination letter, but they also forgot to extend the benefits through the Employment Standards Act period, and they screwed up the vacation pay as well. So these are, important things, but usually the courts don't get enraged over these sorts of things. I usually tell employees, they made a mistake, no big deal, but now, it can be seen as a big deal with these decisions. So the court said in this case, this is no way to treat any employee, much less a long-term employee over 36 years. So you can see the court siding with like this man who's put in 36 years of his life to this company, and really, seeing that as something that's obviously influencing the narrative of the decision. So similarly, the last case I want to just touch on is Morrison and Ergo Industrial. And similarly, the termination letter here too was set up as an all or nothing. So it gave the employee the impression that if they didn't sign off, they weren't going to get anything. And again, the court really honed in on that, saying, no, if they don't sign, they still get their minimum entitlement. And you should be letting them know that. You can't set this up to freak them out thinking they're financially screwed if they don't sign this. That's misleading, and that's a problem. So also in this case, though, the employer delayed in providing the ROE. Usually, again, I see as no big deal. The court felt otherwise. They think, like, at least get the ROE properly done. Come on now. And they saw also, which was probably a big influencing factor here, is the employer tried to say there might be cause to dismiss, and the court found that to be pretty bogus. And it was only being asserted because the employer was upset and they were doing it for tactical and financial benefits, and that it was, not done in very good faith. So overall, the court states, the judge in this decision stated, I find such conduct to be reprehensible. It exceeds what might be considered as ill-advised. The court went on to say employers cannot be allowed to behave in such a fashion without a clear message being sent by this court that this is not acceptable. And they awarded 50 grand in punitive damages in this case. So that's completely a large award in my point of view for the facts of this case. If I usually had an employee come to me with these sorts of facts, I would not be advising them to expect damages like this. So we're really seeing the court sway, and the trend is to really sway over to the side where these types of damages are being awarded. So why this is important for employers and for H2R too, I guess, and I suppose, is being really mindful and careful of what's in your termination letter is more important than ever. And any sort of error in there can be, picked up on by employee counsel and maybe leveraged in a negotiation and leaned on in really driving up the expectations of severances. So to be mindful of getting those ESA minimums really correct, and to be mindful of advising the employee of what their minimum entitlements will be. So I know a lot of termination letters are nicely separated. These are your minimums, and then if you sign, you get this. That's probably the way to go to make sure you don't end up in these types of holes. So the takeaways I have here, I have a little list. Just to remember, with aggravated damages, no medical evidence needs to support these distress damage claims anymore. It's enough for the employee to give evidence that they, couldn't sleep, couldn't eat, needed medication. They don't need to roll in their doctor's notes or their doctor into court in order to establish enough injury to get these aggravated and moral damages. And you can see, based on these cases, we're seeing the trend that carelessness is being penalized by the courts. Diligence is needed in all terminations, and to really proceed with caution and putting termination letters together. Try to avoid just plugging numbers into a template and thinking we're good to go. You really want to ensure that the details of the legal requirements are complied with. And you should stay away, in my view, from using basic template or cookie cutter termination letters. I would really recommend employers to consider reaching out to their HR professionals or legal with any termination, just to ensure you get it right, to put yourself in the best position for negotiating those severance rights for that employee. And lastly, ensure you use careful regard for the individual circumstances and meet these really high standards that are being set up by the courts. So with that, I just say, have a strong HR team and know where to find a employment lawyer when needed as well. Be very careful and mindful when executing terminations or when doing promotions or increases the comp and scope of duties for people going forward. So I think that's about it that I have for you all. I'm happy to answer any questions that you have on this content or any other burning questions you might have for an employment lawyer.
Yeah, we have about 2 minutes. We have about 2 minutes left for questions. So Pamela, if you can stop sharing your screen, and then we'll open it up if anybody has any questions for Pamela.
Did I stop sharing it?
I took it
Yeah,
from you.
you did, you're
Yeah,
good.
okay. I
Thanks,
took it back.
Deborah. I appreciate it.
No worries. That was just
So
amazing. I'm wondering if anyone does have questions,
Yeah.
because that was just
Do we
such
have any
great
questions, any
information.
comments? Anything surprising?
I think surprising, probably.
Yeah,
Which is
so
why
some
it
of
was
these
so
cases
helpful.
definitely read into, and I'm hearing loud and clear from Pamela that employment contracts are so important, and employment contracts need to be given and signed and executed prior to the day that they start. I know that sometimes that's not always possible, but that is the ultimate goal. Anytime there's a significant change, you need to make a change and offer consideration. We talked about what consideration is, and you need to make sure that those contracts are reviewed at least on an annual basis, because some of these cases that Pamela is talking about and others have made significant impact going back to the employment contracts. So you need to, like the termination clause, it has to be very, very, very specific. There's very specific verbiage in there. If benefits are getting continued, benefit continuation must be mentioned. It can't just be a given. So there's so many things. So have those reviewed on an annual basis for sure. Anything else from anybody?
Question. I just put it in the
Yeah,
chat.
go ahead,
I was
Margarita.
just going to say that. Thanks. Go ahead.
So my question is just about consideration, and it comes up a lot in our practice, right? And from a business sense, like things, at least in my company, are very quick moving. And so does consideration always have to be in dollars? I know sometimes we do things like promotion, but that's more scope and growth oriented. Here's more like a bigger capacity in which you can showcase, and grow, rather than always having dollars attached to it necessarily, or it doesn't always happen at the same time every time. So are we then in kind of muddy waters when it comes to consideration in those situations?
Yeah, that's a great question. And I would say, the consideration needs to be measurable. It should be quantifiable. And I think it's too subjective, giving someone, opportunity. That's really subjective. And I think you run a huge risk trying to rely on something like that as consideration. So I think it needs to be a tangible, quantifiable benefit. So money is the best thing to do. It can be a signing bonus, an extra bonus, adding a savings program, an RSP, a new group benefit, maybe life insurance, something that has quantifiable objective value is really what I would suggest using. So I don't think opportunity would cut it. And in fact, I think added responsibility with no increase or consideration by employee council could see as, you know, being taken advantage of perhaps, and not a positive thing, right? So
What
yeah.
about increased PTO?
Yeah, increased vacation time or personal days, absolutely, that can have a quantifiable value, right? Because you're getting that pay for time off, so that definitely could be consideration.
Okay, so no title changes without comp changes is kind of the basic.
Yeah, keep it to the money is the good way. If you can't easily calculate the money value of it, then it's probably going to be a problem. Yeah.
And if you're doing annual salary increases, it's a good time to look at doing something like a change in a contract, because you're doing that anyway, and that would be considered consideration because you're giving something, you were going to do that anyways. It just depends on the timing, right?
Yeah. Absolutely.
I
So
know
there's
some-
another question here.
Yes, I was just going to say, I know some people have to jump off, so feel free, but we have at least one more question here. We'll do that and we will wrap up in a minute, but I know some people do need
Yeah,
to.
I think this is a great,
This is a great question.
Yeah.
So
I
Margaret
can't say I
says,
know of a decision coming out of the courts yet that's kind of looking at this balance, but I do know, and I wish I had the case name in my head, but I don't. I know of an arbitration decision though that has recently come out that has kind of looked at this issue in the case of complaints coming from an employee, where the employee is complaining and gets fired, and then of course says this was retaliation for my complaints and retribution for my complaints, and the arbitrator said no, the complaints had nothing to do with it. It was the way you handled your complaints, the way you made the complaints, your tone, your personality, your delivery, the way you reacted. Those are what the problems were, not the actual substance of the complaint. So what I thought, I'm mentioning this arbitration decision, is a trier of fact recognizing that, you know, personality, behavior, all of that factor has to be considered, not just the underlying complaint or issue that the employee is talking about. And I think it does show an opening to look at whether the employee is being dramatic, whether this hypersensitivity and the actions of the employee are objectively reasonable or not. So I don't know of a court decision looking at a hypersensitive employee, but there is, if you're curious, you can Google the thin skull principle. This is very old legal concept in law, where the thin skull is kind of like the oversensitive person that reacts completely unreasonably compared to the normal and reasonable person, and how that's treated in law. So I would say that I could anticipate that concept in law being coming back into the court decisions with employment law cases in the future, trying to find a balance between that thin skull rule and applying the law to hypersensitive people, but also putting kind of a lid on the drama as well. I can tell you judges aren't the most tolerant of drama and BS. Ironically, they kind of cut to the chase and see through it all. So I'm sure with the right employee litigant, we'll see decisions where the courts also tear up employees and tear them apart a bit if they're being over dramatic. But I don't know of an example right now, but great question. I'm sure there'll be one in the next few years.
well, Maud had added a comment as well to Margaret's question, just saying that without medical documents being required to prove the distress, you know, that's where these questions come up. It seems so subjective.
Yeah.
And that's what the worry is. And I'm sure even for you guys offering guidance, when it's so subjective, it's really hard for you to, you know, be able to get good guidance.
Yeah. And I think that's why you see the courts getting technical with these ESA requirements, because those are objective pieces of evidence they can kind of rely on. They're probably not happy with the employer, but really focus in on these technical errors because it's a lot easier to hang your hat on those than the subjective nature of these disputes at times, right?
Yes.
So
Margaret has another add-on here. She has an
Yes.
employee she's working with that says every time they communicate with her, that she causes him stress. So I think
Yes.
maybe she's worrying that a pattern is developing here.
You
Yeah.
cause them stress, Margaret? You're the last person in the world that I would think would cause anybody some stress.
That's exactly what I'm saying. Like the approach is so gentle and
Oh, my
so
goodness.
kind and so considerate. And I think every single time I've talked with that employee, they've said, oh gosh, I'm so glad. I just was so distressed about like this call, or like it's unreasonable, right? It's a basic communication. It's not,
Wow.
and every single time. So you can see it coming, right? Like for a long time in advance. So
So how
I
do
was
you
just
protect
curious.
yourself against that, right?
Right. And
If it
that's
goes the
me,
wrong
not the
way.
employer. So when the employer is the person, their manager or
Oh, she's cut out on
someone
us.
with some actual clout in the
Oh, there you go.
organization, what's the response to that, right?
Mhm.
Sorry, some bad internet here. So just I was
Yeah.
thinking the employer, like the different people that contact, everybody's afraid to call her, basically. What do we do? Mhm.
Yeah, it's a tricky environment we have out there right now. No doubt, but that's why I wish I knew the name of that arbitration case, but I think it's some light, and seeing that triers of fact are going to start drawing a line and kind of checking employees that approach things with too much drama, negative tones, things like of that nature. We may definitely see corrected.
All right,
So
we're at
you
10
have
after,
to
so
have-
we should probably wrap up, Deborah, unless there's
Yes.
another question for Pamela.
I don't see anything coming in.
Okay.
Well, that was just such a great meeting. Thank you so much, Pamela. Thank you so much, Jackie. The information and the value you guys have added here is just really tremendous. So thank you so much. Thank you everyone for giving us your time to be able to participate through this. And we just wish everyone a really great day ahead.
Thanks so much for having me. Have a great day.
Thanks,
Bye,
everyone.
everybody.
Thank you.
Thank you.
Have a great day.
Thanks. Bye.
Bye.
We'll see you next quarter.